HMRC is not like any other creditor your company owes money to. Listen, a supplier will chase you, a landlord might threaten you, and a bank is going to write letters to you. But HMRC, listen, HMRC has powers that no other creditor in the UK has. The powers to collect, the powers to investigate, the powers that follow you, the director, personally, sometimes even after your company's gone. And most directors, they don't find out about how far those powers go until it's already too late to do anything about it. Now in this video, I'm going to show you exactly what HMRC's role is when a company becomes insolvent. I'm going to tell you what they can do, what they're looking for, and crucially, what you can do about it. So it's Chris Word and I'm from Director First. We work exclusively with UK company directors and we help them navigate financial distress and formal insolvency processes. HMRC is involved in the majority of cases that we see. And in almost every single one of them, the director is surprised by something HMRC can do and that they didn't know about it. Now, by the end of this video, you're not going to be surprised. You're going to understand HMRC's role at every single step of the insolvency process, from the moment your company falls behind on tax, through informal insolvency and beyond. And there's one thing I'm going to cover towards the end of this video that has changed significantly, okay? And this is the thing that most directors and even some accountants, they don't fully understand it. And it directly affects you and personal exposure. It's not going to go away. So stay with me to the end for that one, okay? Right, here's what we're going to cover today. It's going to be in 4 parts. Part 1 is what kind of creditor HMRC actually is and why that matters more than most people realise. Part 2 is what does HMRC do when a company formally enters an insolvency process. Part 3, the personal liability risk for directors like you. This is the part where it gets really serious. And part 4, what can you do about it? And how early action can actually help the outcome. So let's start with something that sounds pretty simple, but probably isn't. What kind of creditor are HMRC? Most people out there, they assume all creditors are equal, and the truth is they're not. When a company becomes insolvent and an insolvency practitioner gets appointed, and their job is to try and recover some money to distribute out to creditors, they do it in a strict order, okay? And it's that order that determines who gets paid and who doesn't. Now, for most of the sort of last 2 decades, HMRC sat in something that we call the unsecured creditor category, right? So same as your suppliers, same as your landlord. Basically at the back of the queue, getting whatever was left, which in most insolvencies was very little. Now that changed on the 1st of December 2020. Now, just to bore you a little bit, it was called the Finance Act of 2020. And HMRC was restored to what is called preferential creditor status for certain tax debts. Now, what does that mean to you in plain English? Well, it means HMRC now jumps the queue, ahead of most unsecured creditors and ahead of some floating charge holders. Now, the specific debts that carry preferential status are things like PAYE, and that's the income tax and national insurance you deduct from your employees' wages, okay? They're also preferential on VAT, CIS, student loan deductions. So let's say your company owes 50 grand in PAYE arrears and 50 grand to a trade supplier, and the insolvency practitioner gets 60 grand in from the assets. In theory, HMRC gets their 50 grand first and the trade supplier would get 10 grand. Or nothing if the insolvency practitioner's costs are into it, which happens a lot. Now, why does this matter to you as a director? Well, I'll tell you why it matters. Because it changes how an insolvency practitioner addresses what creditors are owed. And it changes the pressure HMRC can apply before insolvency even begins. They now know that they're near the front of the queue and they kind of act accordingly. So that's what HMRC is. It's a preferential, powerful creditor with a priority position most people don't know about. Now, what I want to do now is look at what they actually do once a formal insolvency process begins, because this is where it can get quite detailed quite quickly. Right, let's get into it. The moment a licensed insolvency practitioner is appointed, whether that's in the liquidation or in an administration, the HMRC gets notified and they submit what's called a proof of debt to the insolvency practitioner. And essentially it's their formal claim. It's a document that sets out exactly what the company owes to HMRC, and it'll be for PAYE, VAT, corporation tax, penalties, interest, every single penny. And here's something that directors are always surprised by. HMRC's numbers are very rarely wrong because they've got access to everything. The RTI submissions, that's where your payroll gets submitted. They've got your VAT returns, they've got the corporation tax returns. And if returns are missing, they'll just estimate what's owed. And by the way, they'll estimate high. Now, if your company has been filing late returns or they've not been filing at all, HMRC will raise something that's called a determination, and that's their assessment of what they think you or the company owes them. And it's based on previous returns and internal data. Now, you can challenge a determination, but the burden of proof's on you. And an insolvency practitioner working through your records isn't always able to reconstruct the evidence that you can. So sort of once you're in insolvency, it's almost pointless. Now, HMRC also has the right to attend a creditors meeting to ask questions. It happens very, very rarely. But if they come, they can take it really seriously, particularly in cases where significant PAYE arrears have arisen, because they know that money came from employees' wages. It was meant to be deducted at source, but it never reached them. Now, this brings me to something I need you to keep in mind here, because in part 3 I'm going to show you how HMRC can pursue that money directly from you, the director, personally, and not the company. And that's the part that can catch a director completely off guard. Now, you know what HMRC claims for in an insolvency. Now you know what HMRC claims for in an insolvency, and you know how they claim it. But the role doesn't end there when the liquidation is done. Certainly not if you think you as a director, if they think that you as a director are personally responsible for some of this. And that's what I want to talk about now, is personal liability, when HMRC is actually going to come to you. And this is where directors get this completely wrong, and I want to make sure that you are not one of them. Let me have a quick drink. There is a widespread belief among a lot of directors that limited company protects them personally. And what basically happens to the company stays with the company. And you know what? In 90% of cases, that's true. Limited liability exists for a reason. And I want to be clear here, it does protect most directors. But HMRC has got very specific tools that they can pierce that protection with. And they are starting to use them more. Tool 1 is a personal liability notice. If HMRC believes that unpaid national insurance, they were basically not paid due to fraud or neglect by the director, they can issue something called a personal liability notice direct to the director, not to the company, to you. And this makes you personally responsible for that national insurance debt. Even if the company's in liquidation, even if you're not a director anymore, what I want to try and hammer home to you is like, what is neglecting HMRC eyes? Because that's the key point here. And it's the key thing is like knowing your company couldn't afford to pay PAYE and you were paying other creditors instead. Like carelessly racking up PAYE debt, continuing to trade, even after it was clear that the company was never ever going to recover from the insolvent position. Now, another thing is if you take advice and then you don't follow the advice you've been given. Like these are fact-specific decisions, if you will. And HMRC can investigate each case. And if the facts support it, they will issue these PLNs. Now, another tool HMRC use is director disqualification. Now, HMRC will work very closely with the Insolvency Service, and if an insolvency practitioner's report identifies conduct that concerns them, so this could be patterns of unpaid tax across, multiple different companies, they can refer the matter for a disqualification. Now, a disqualification order can run 2 years at the minimum, all the way up to 15 years. And during that period, if it gets granted, you can't act as a director for any UK company. You can't be involved in the promotion, formation, or management of a company, except for explicit court permission. Now, this isn't rare. Whereas PLNs aren't, they're not done every day. Thousands of directors are disqualified every year. And unpaid tax, particularly PAYE, is one of the most common triggers. Now, 3 is what I said about at the start when it changed. There's some rules changed. It actually changed back in 2020. And it's Schedule 13 of the Finance Act 2020, and it introduced something called joint and several liability for tax avoidance and repeated insolvency. Now, what does that mean in plain terms? It basically means that if HMRC can show that a director has been involved in a number of insolvent companies within sort of a 5-year period, and that there are outstanding tax liabilities, they can make the director jointly liable. And they can also make the director jointly liable of the tax debts of the new company, even before the new company becomes insolvent. And this is what is called a joint liability notice. Now, let me be really clear here about who this targets. It targets the behaviour known as phoenixing, where a company is liquidated, leaving behind lots and lots of tax debt, and the director immediately starts a new company doing the same thing with the same people. HMRC now has the legal power to follow that director into the new company and hold them personally liable for the new tax debt, even before it goes unpaid. Now, if you are in or you are heading towards a 3rd or 4th insolvency, this isn't theory, this is a real active enforcement, and it's something you really need special advice on before you do anything else. So, from what I've said so far, HMRC have got very significant tools before insolvency, during insolvency, and after insolvency. But it doesn't mean that you're powerless. Like, there's a lot you can do, and most of it depends on, like everything, doing it early enough. Now, here's the things I want to leave you with, right? HMRC will respond to engagement. They're not how can I say this? They're not, despite how it can feel, simply out to destroy businesses. That's not what HMRC do. They've got targets, they do have powers, and they do have patience with a lot of people. But they've also got to follow processes, and they will be more communicative to a business that engages with them early. So step 1, talk to HMRC before they escalate. If your company's behind on PAYE, VAT, corporation tax, they've got a dedicated helpline. And you can speak to them, tell them that you're in financial distress, and come to some type of a deal. You can request something called a time to pay arrangement. And that is an agreement to pay your tax debt in instalments over a period of time that they consider affordable. That can be 2 years, 3 years, 5 years. Might be 12 months. It depends on a lot of things. Your compliance history is important. If you've never paid a tax bill and then ring them up saying that you want to pay them over 5 or 6 years, you're probably going to get laughed off the call. HMRC will agree to time to pay arrangements. But you've got to demonstrate to them, A, you're trading, you're engaged, and your plan is realistic. Now, the most important thing here is for you to act before they act. You ringing them when they've issued a winding up petition's too late. If you are getting chased by the big debt team and you've buried your head in the sand for 6 months, you've lost a lot of goodwill. Once enforcement begins, that window for informal arrangements is going to narrow dramatically, okay? Now, step 2, I think you also need to understand what you personally owe before certainly any formal insolvency process happens. Because, let's be right, some insolvencies are unavoidable. So you need to understand what your personal exposure is before you appoint an insolvency practitioner. Have you got personal guarantees? Have you got an overdrawn loan account where you're going to be asked to repay it back? Are you a director who's done multiple phoenixes? And this could really bite you in the arse because, like I say, HMRC, they're clamping down on phoenixing now. And these are questions you should be asking yourself way before you start pulling the trigger on any formal processes. Now, remember, once an insolvency practitioner is appointed, they're going to investigate you. That's their job to do it. They're going to flow information to HMRC. And if you are a serial offender, this is where personal claims can start running. Now, I always believe early intervention provides more options. Now, I want to be calm on this point. Step 3 is don't confuse company debt with your debt personally. Okay, that's not specifically what this is about. Because in 99% of cases, a director who has behaved properly, not committed fraud, not been neglectful, hasn't had multiple failed businesses, they will not face personal liability from HMRC, okay? Most directors will go through insolvency, they close the company, they deal with the process properly, and in a lot of cases they can start again. The risk isn't the insolvency itself, sometimes it can't be avoided. The risk is handling it badly, delaying it, ignoring it, managing it without advice. That is where personal consequences come from. So here's what I want you to take away from this. HMRC is not your biggest risk in an insolvency. The ignorance to HMRC is. Not understanding what HMRC can and can't do, not knowing where your personal liability is, not acting early enough to protect creditors and yourself. That's what turns a difficult business situation into a personal financial crisis. Now, if you are watching this because HMRC is chasing your company or you're worried that things are heading to a position where you're never going to recover, you need to get some advice. Like, book a call with us, we'll speak to you. The link is in the description, it's confidential, it takes about 60 seconds to book. Now, if you're having some issues with HMRC, and you want to find out more about how you set up a time to pay arrangement, go and click on that video there. It will tell you what you can do, what you can't do, how to speak to HMRC. It will give you all the information that you need to try and set up a realistic time to pay arrangement. Chris Worden, Director First.